This right here is the moment that we all knew was coming. Man, it's your boy Deezy. If you ain't already subscribed to the channel, hit that subscribe button, hit that like button, and share this video. We all knew this moment was coming. Judge Glanville has been biased the whole time. He's been biased the whole time. And the icing on the cake in this situation is when he had the meeting with the witness, Little Woody, without notifying the defense. That was the icing on the cake. See, the justice system isn't fair, but they see that the world is paying attention to this case. If they keep Judge Glanville on the case, it is going to solidify to all the people that have doubt that the system is messed up. So they had to remove him so that it can look as if the justice system works. Pay attention to this. The world knew he was wrong. He knew he was wrong. But what they do is they follow the colleagues. So now if other judges are doing certain things that they're able to get away with and they're not questioned, then they'll do the same thing. It's like if you see the workers that are next to you, equivalent to you, your coworkers doing certain things and things are not being addressed, all you do is fall in line and fall with the program. And we see this right here. They got the judge, it's a female judge now. Her name is Shakura Ingram. She's a black judge. And if you see, most of the attorneys in Fulton County are black. And we know that from watching this trial that the new judge knows that she's under a microscope. So I doubt that we see any of the bias stuff that we seen from Judge Glanville. Judge Glanville was already in the groove of the way he wanted to do things, and he thought that nothing can happen to him. And when people get position of power, they think that they really control the situation. You control nothing that you involve yourself with as in a job for any state or any entity. You don't control anything. You can be fired, you can be removed. But people, when they get in a position, they feel that they're able to do what they want. And in this situation, we see that Judge Glanville did not have the power to do what he thought he did. He was removed. Everybody can be replaced. Now, the way things look now, will Thug get a mistrial? Who knows? But things are looking in his favor in this situation. And it says, Fulton County Superior Court Judge Glanville has been removed from the YSL case in Fulton County. Fulton County Judge Rachel Kearse issued her ruling on the motions submitted by attorneys for Jeffrey Williams and DeMonte Kendrick and attorney Caleb Bumpus on July 15th. See, Little Woody's attorney knew what they were doing were wrong. And I'm sure she was the one who tipped the information off about the meeting, because she knew that they were wrong for having a meeting without notifying the defense. But the judge tried to make and seem like there was nothing wrong with that. But we all know something was wrong with that. So in her ruling, Kerr stated that while the court has no doubt that Judge Glanville can and would continue presiding fairly over this matter, if the recusal motions were denied, the necessity of preserving the public's confidence in the judicial system weighed in favor of excusing Judge Glanville from further handling of the case. Pay attention. So they're making an excuse as to why Judge Glanville was removed. So let's see here. What we got here? This here is the motion. This is the motion that was, let me see here. Hold on. This is the motion that was entered in the order that the judge ordered in this case. Hold up. Let's see what we got here. So, let me see. All right, hold up. Let me see how I get this thing up here. But they got the motion. They got the motion up here. The motion is up here. Hold up. I'm ready to tell you what the motion says. All right. We're going to tell you what this motion says. All right, hold up. 1 second. All right, we're going to get it right here. All right. So it says, this case is before the court and considered various motions of recuse included from the defendant, DeMonte Kendrick. Motion to recuse Chief Judge Earl Glanville filed on June 12th, 2024. Caleb Bumpus, motion to quash the show, cause order, and recuse Judge Glanville. So YSL Woody's attorney, she filed a motion as well to recuse the judge because she knew that the meeting was improper. But being as though that she's an attorney and, you know, they have to follow orders of the judge, she had to participate in the situation because she was Woody's attorney, right? So Young Thug, Jeffrey Williams, he submitted a motion as well to disqualify and recuse Judge Glanville from all further dealings in the above referenced case and amended supplement. The specific facts necessary to determine these recusal motions are well documented in affidavit, court filings, certified transcripts, and video recordings available on YouTube. Having considered the recording evidence, the record evidence, and applicable case law, the court finds as follows. This court previously considered and denied. Hold on. It said this court previously considered and denied defendant Kendrick's motion to disqualify Fulton County judge from ruling on acute recusal motion, and the position of defendant Williams' amended supplement that sought this court's recusal. These recusal motions arise out of a multi-defendant prosecution brought by the Fulton County District Attorney alleging gang activity and associated crimes. Although there were 28 defendants named in the indictment, only 6 were being tried as of June 7th, 2024. The motion to recuse all arise from the same circumstances related to the state's witness, Kenneth Copeland. So this is all from Little Woody from the meeting. On June 7th, 2024, the state intended to call Kenneth Copeland to testify. Prior to his testimony, counsel for Copeland, Jonathan Melnick, appeared and indicated in open court that Mr. Copeland did not wish to testify and intended to invoke his Fifth Amendment privilege against self-incrimination. So they're saying that he didn't want to testify, but once he got brought in the back to the judge chambers and they put that pressure on him, telling him that they're going to send you to jail if you don't cooperate. Then he cooperated, but at the same time, he went left on him. You feel me? And he wanted to invoke his Fifth Amendment, self-incrimination. Judge Glanville brought Mr. Copeland into the courtroom and discussed with him the effect of immunity order Judge Glanville had entered that granted immunity to Mr. Copeland. So they gave him immunity and they wanted to tell him, we're giving you immunity, we just want you to testify. This case is so important to the world that we're giving you immunity, we just want you to testify. This is the games now inside of the system that people do not pay attention to, right? So Mr. Copeland, the judge, specifically advised Mr. Copeland that if he invoked the Fifth Amendment and refused to testify, the state would ask for Copeland to be held in contempt in jail. Judge Glanville also advised that if asked, Judge Glanville would jail Mr. Copeland for refusing to testify. So they told him, we're going to sit you in jail until the end of the trial if you don't testify. That's what made him get up there and start saying whatever. He like, oh, they're going to keep me here. I want to go home. After the discussion, Mr. Copeland spoke to his attorney and then indicated he would testify. Once called, Mr. Copeland was asked to specify his age, and instead of answering, he stated, I plead the fifth. Judge Glanville excused the jury, right? Hold up. Judge Glanville excused the jury. Let's get this joint right. Hold up. Let me get where I need to be at. And then advised Mr. Copeland in open court that he was in contempt and ordered him jailed until Monday, June 10th, 2024. Right? At which time, Judge Glanville told Mr. Copeland they would revisit Mr. Copeland's willingness to testify after they locked him up because he said he wanted to plead the fifth, which he had a right to do. So they lock him up and say, all right, we're going to sit you in jail for the weekend so you can be nervous and scared. Come back on Monday, and I hope you make a better decision, because if you don't, we're going to sit you in jail. And the better decision is you need to cooperate. You know what I'm saying? This is the games that they play. If the man was going to cooperate and testify, let him do it on his own. He already been talking, working with the police. Why do you have to put that type of pressure on him to intimidate him, knowing that was wrong, to get him to testify? Now, if a person's willing to testify and they testify, okay. But if they're not willing to testify and they change their mind, let that be what it is and go through the process if you want to hold him in contempt. But don't try to give him like an ultimatum. If you don't testify, we're going to hold you in contempt. That right there, that's trying to threaten him into testifying. Whatever consequences he was going to suffer behind it, that's the consequences that he has to suffer. But trying to threaten him because the judge wanted this testimony so bad because everybody knew that he was being specific about certain things. So his testimony is going to hold a lot of weight. You understand what I'm saying? So, and it says, Mr. Mellick spoke with Mr. Copeland and then reiterated to the court that Mr. Copeland still intended to invoke his Fifth Amendment right if called as a witness. Judge Glanville indicated he would revisit the issue with Mr. Copeland Monday the 10th, and then the court was adjourned for the day, right? On June 10th at approximately 9:10, Judge Glanville met with counsel for the state, Adrian Love, and stand-in counsel for Mr. Copeland, which was Caleb Bumpus. The meeting took place in Judge Glanville's chambers. So they wanted Woody to testify so bad, they took him in chambers, sat him down, probably buttered him up, gave him something. Yo, you might want to testify or we're going to have to jail you, and, coercing him into testifying. Let him make that decision. That's a decision Woody has to make. Not trying to threaten him through the court. This is how they do the legal process the way they want to and expect us to believe that it's fair. It's not fair. All right. So counsel for the trial defendants did not participate in the meeting and were not aware of the meeting taking place. They didn't even know. The transcripts reflect that Miss Love told Judge Glanville that she wanted the meeting to both impress upon Mr. Copeland the risk of refusing to testify and allow Mr. Copeland to ask questions before he testified. Miss Love also expressed concerns to Judge Glanville about Mr. Copeland's representation. Miss Bumpus, Miss Love, and Judge Glanville also discussed the scope and effect of the state's grant of immunity to Mr. Copeland. They wanted him to testify so bad, they took him in the back and did things against the rules. And they knew that Caleb Bumpus was going to tell the other side about this. They didn't want her to be his lawyer. They wanted to keep this under the rug. And the crazy thing about this system is if it was certain lawyers, it would have been kept under the rug. Certain lawyers would have kept this under the rug because they want the conviction. But Miss Bumpus said, hold on. I'm not going to allow them to do a Young Thug and these defendants like that because I know this is wrong. And she took it upon herself to enlighten the other side on what was going on. You understand what I'm saying? So it says, let me see here. We're going to go down a little more here, y'all. We're going to go down a little more here. All right. It says, Mr. Copeland was then brought to Judge Glanville's chambers where he spoke with and asked questions of Miss Bumpus, Judge Glanville, and Simon Hilton, counsel for the state who had joined the meeting. So it was a whole nother person that was counsel for the state that was invited to the meeting, but the defense wasn't. Boy, I'm telling you, these are them games. These are them games. And you don't understand these games until you in that position where if it's a situation that you got to defend yourself, you might be right, you might be wrong. But when you got to defend yourself, that's when you see that they got a lot of games up there. It's not just cut and dry. The justice system follows the rules. No. They do what they want up there. I'm going to tell you that now. All right. So it says during the time, the state advised Mr. Copeland that he could remain in custody until the conclusion of the trial and all the defendants in the case, not just the 6 currently on trial. So what they did, now listen to me, y'all. This is how they scared Woody. They told Woody that if you don't testify, you're going to have to sit in jail until these people go to trial and the other people that are waiting for trial go to trial. Because I think it's about 8 more people, if I'm not mistaken, that haven't even been scheduled for trial. So they told Woody that if you don't testify, you're going to have to sit in here until the other people go to trial. And that's when Woody said, I got to figure this out. I'm going to have to try to say something. And after the meeting and immediately before Mr. Copeland was brought out to testify, the defendant Williams' lawyer Brian Stills advised the court that he was aware of the in-chambers meeting that morning. Mr. Steele objected to the ex parte and the lengthy collage occurred between Mr. Steele and Judge Glanville, in which Judge Glanville inquired how Mr. Steele became aware of the meeting. Now that's crazy. The attorney knows that the meeting was illegal and that it shouldn't have took place. Shouldn't have took place. The rules have been broken. And when he addresses the situation, all the judge say, how did you know about this meeting? So that lets you know that the judge was doing something wrong. If the judge knows that he's supposed to make sure that the other side knows about what's going on, and then he doesn't, but then questions, how did you know about this? He knew he was wrong in that situation. So, and Mr. Steele declined to reveal the source of his information, and Judge Glanville held him in contempt. So now the judge held Mr. Steele in contempt because he didn't want to tell where he got the information from. And I'm sure he got it from Miss Bumpus. I'm sure he got it from Miss Bumpus. And it's an attorney's right, if they know something's going wrong and it's not right, they're supposed to reveal it. They're supposed to reveal and be truthful. The attorneys take an oath to be truthful to the clients and to be truthful to the court. And she was truthful about the situation, right? So he didn't tell him where he got the source of information from. They held Mr. Steele in contempt. Through Mr. Steele, though Mr. Steele was allowed to remain in the courtroom on behalf of his client, Defendant Williams, ultimately, Kenneth Copeland did testify June 10th, 2024, and was later released from custody. The next day, Judge Glanville issued a show cause order and requiring everyone to be present at the ex parte meeting. This is what he should have did at the meeting with Little Woody. He should have sent notice to make sure everybody was there for the meeting, but he didn't do that. He said, we're going to scare Woody into testifying, and this then backfired. All these things that are going on in this trial are ways for Young Thug to appeal. He has massive appeal issues in this situation, right? So the next day, Judge Glanville issued a show of cause, and he wanted everybody to appear, right? And the show of cause is as to why they should not be held in contempt. The judge wanted to hold them in contempt so bad because they didn't reveal the information where they got him having an illegal meeting with the witness, right? Well, check this out, right? And it says, the judge asking why you shouldn't be held in contempt for disclosing information about the ex parte meeting to defense counsel. And a amended show cause order was later entered, setting July 1st for an, what does that say? Camera review of the transcripts in the ex parte meetings, right? The first motion to recuse, followed by the defendant Kendricks on June 12, 2024. Mr. Kendricks' motion seeks to recuse Judge Glanville for his involvement in an alleged improper and coercive ex parte meeting with the state. So they're saying that the judge was back there trying to coerce with the state Little Woody into testifying, and they know that's breaking the rules, right? Okay, and Judge Glanville determined the recusal motion was timely, reported by an affidavit, and a cursory review contains assertions of facts to support the allegations of bias. However, Judge Glanville ultimately determined that because there was no way to verify the veracity of the information contained, hold on. All right, hold up. However, determined, okay, that the veracity of the information contained in the affidavit, there was no actual evidence of the extent of the discussion during the in-chambers meeting. The affidavit was legally insufficient, and the motion to recuse did not require referral to another judge. You hear me? Yeah, they got him removed. He's definitely off the case. He's off the case. And it's good because you've seen how biased he was. The judge is supposed to be a referee. And what it looked like with him, it was like he was just pulling to the other side. So, all right, we're going to check this out here. Hold on. On June 14th, Caleb Bumpus, and that was YSL Woody's attorney. On June 14th, Caleb Bumpus then filed a motion to quash the show cause ordered or to recuse Judge Glanville from presiding over any contempt actions against Ms. Bumpus resulting from alleged disclosure of the ex parte meeting. So from the door, Judge Glanville tried to go at Caleb Bumpus from the door, and she knew he was coming, but she knew he was wrong. So that's why she filed the motion ASAP to cover her back. You know what I'm saying? And now she got her YouTube channel, so it's going to change the game for her. You know what I'm saying? All right. So Ms. Bumpus, resulting from alleged disclosure of the ex parte party on June 17th, Jeffrey Williams, Young Thug, filed a motion to recuse Judge Glanville. Divorced from its hyperhole, Mr. Williams' motion and supplement also seeks to recuse Judge Glanville because of his involvement in an ex parte meeting, which Mr. Williams also alleges was improper and coerced. Yes, it was. We all know it was improper and it was coerced. You know what I'm saying? And it's messed up. But this is the games they play when you don't know. Thug's lawyer know what's going on, so he put the pressure on him ASAP. It made it a whole different situation. And let me see here. Mr. Williams' motion alleges both actual bias and the appearance of bias because Judge Glanville allegedly participated in the accusatory process when he met with Mr. Copeland, and Judge Glanville became embroiled in the controversy when he has held Mr. Williams' lawyer, Brian Stell, in contempt. So when he participated in that meeting, that automatically made him break the rules. He knew he wasn't supposed to participate in that meeting. But you got to understand that the state and the judge are together. The judge is supposed to be a referee, but the judge works for the state and the prosecutor works for the state. Why wouldn't they be together? How does the world not understand that? The judge and the prosecutor are together, but it's made to look at us as if they're a referee. We supposed to look at it like they're the referee. Okay. All right, so now listen here. On July 1st, 2024, the day appointed for the parties to review redacted transcripts of the ex-party meeting, Judge Glanville announced that he was releasing the entirety of the transcripts of the ex-party meeting and was taking judicial notice of and making record regarding certain matters associated with the ex parte meeting. Most of what Judge Glanville relayed was collection of record evidence about the recent circumstances in the case. Judge Glanville also explained how he became aware of the state's request for the ex parte meeting. In addressing the circumstances of the contempt against Mr. Steele, Judge Glanville explained that the court's purpose and concern of pursuing information about the security and confidentiality of his chambers. All the judge was worried about was how he got the information. He wasn't concerned that he made a bad decision on involving himself in something that he shouldn't have been involved in. You understand what I'm saying? Crazy. So what's going to happen now? They got a new judge on the case, bro. And the judge name is Shakura Ingram. That's her name, Shakur Ingham, and she's going to take over the case, and the trial is going to resume. So that's going to be happening probably this week or next week once they get everything all lined up. Right? And let me see. Judge Glanville advised that he had instigated an investigation into surveillance footage, but had reviewed such footage for timeline security. Judge Glanville then explained his view that the ex parte meeting was proper under Georgia law and outlined relevant laws that supported his inherent authority to hold such a meeting. Judge Glanville maintained that no one gained a tactical advantage as a result of the ex parte meeting. Judge Glanville also questioned defendant's right to be present in the ex parte meeting because the issue under discussion was between the state and the witness, who was represented by counsel. See, now Judge Glanville is trying to say, now listen people, he is trying to say that Little Woody was in fear. So being as though that he was in fear, they didn't have to let the defense know about the meeting. This is what the judge is trying to push to the people, that Woody was in fear, and being as though that if he's in fear, they don't have to let the other side know about the meeting. So he's trying to say that he wasn't wrong in the situation. Nah, he was wrong. But this is the game. And this is the game with the law. When they find technical things and they try to forget why they was wrong, they're looking at a technical issue to make their wrong be right. Pay attention to that. They're looking at a technical issue to make their wrong be right. Wow. All right. So now we're going to go down a little more, man. This is the motion now. I'm reading through the motion. And if you go back and watch the live, you're going to hear, man, the games that the system played is not to benefit you at all. It's to benefit them. You could be right in the situation. They doing what they want to you. After making this record, Judge Glanville announced that the show cause hearing was canceled and that the recusal motion filed by Mr. Kendrick and Mr. Williams and Miss Bumpus were being referred for consideration from another judge in accordance with Uniform Superior Court Rule 25-1 through 25-7. The motion to recuse was assigned to the court for consideration. The motion to recuse was signed to the court for consideration. The judge know he was wrong, man. And he knew that he had to send this case to another judge. Because if y'all pay attention, he was ruling on all the motions himself. He was the one making decisions on all the motions, and he was just saying denied. Anything that they said that the defense said that was wrong, and the rules might have been broken, he was still denying it. He was still denying it. So he had to send this to another judge. And for the judicial system to gain any trust from the public, they had to remove him. The whole world is watching this. You don't have to know law to see something's not right in this trial. You understand what I'm saying? But we're going to say here, legal framework. We're going to go to the legal framework, all right? After making this record, okay, motions to recuse are governed by a specific legal framework outlined in Rule 25 of the Uniform Rules of the Superior Court. A party seeking recusal must file a timely motion supported by an affidavit clearly stating the facts and reasons for the belief that bias or prejudice exists. The affidavit must be definite and specific and described. You understand what I'm saying? The games. But you got to be on it. You got to do your own research, man. You have to do your own research. And once such a motion is filed, it is the duty of the assigned judge to temporarily cease to act upon the merits of the matter and assess the timeliness and legal sufficiency of the affidavit and alleged facts. If all the criteria are met, i.e., the motion is timely supported by an affidavit and the fact alleged might warrant recusal, another judge shall be assigned to hear the motion to recuse. When considering a motion to recuse, the assigned judge should be guided by Rule 211 of the Revised Code of Judicial Conduct, which provides the judge that judges shall disqualify themselves in any proceeding in which therein partially might be reasonable be questioned. So the judge is supposed to remove himself if it's in question about him breaking the rules and being impartial. For real. So if a motion to recuse satisfies the threshold criteria, the assigned judge must refer the motion for reassignment and may not oppose the motion. That's Moody versus Magnolia. The judge whose recusal is sought may not respond to the motion or attempt to refuse the allegations which stand denied automatically. No matter how false or even defamatory the judge might know of perceive the allegations to be, a judge cannot become actively involved in presenting evidence or argument against a motion seeking his recusal without the defense itself becoming a bias for recusal. Woo! It might be too much for some of y'all, right? But this is what they're going off guiding us. The justice, the legal system, this is what they base how they handle us. And the lawyers know that most of the world have no idea. And most of the world won't go research. They know this. That's why they take advantage of us. They know this. But when you go to research it, they're upset. They don't want to hear it. Because you researched something that they had to go to school for. It's crazy. And analysts and discussions. Here, Judge Glanville had previously announced on the record that the motions were timely and supported by an affidavit. In transferring the case to another judge for consideration, Judge Glanville necessarily determined that the third criteria was satisfied, i.e., that recusal might be authorized if the fact alleged in the motion was assumed true. Therefore, Judge Glanville was required to refer the motion for reassignment and was prohibited from opposing the motion. Now, he would have been the one to make the decisions if he could. If he could have made decisions, he would have made decisions. But he know he couldn't make the decisions. Thug gonna come home, man. He gonna come home, but I hope that something good comes out for him ASAP, but he has a lot of pill issues. So I really think that Thug is gonna come home because the case, it's like the prosecutors and the police, right? They only can make one mistake. You find the mistake that they make and you ride it. You understand what I'm saying? You find what they did wrong and you ride it because they're looking for something that they feel you did wrong and they ride it. So you got to do the same thing back. You got to do the same thing back. And don't allow them people to scare you into taking a plea. Them people will try to scare you into taking a plea. You might not even done it, but they'll scare you. Now, if you are a career criminal, you might want to consider taking a plea. But if your record is not that bad, you can rumble. You hear me, y'all? And that's for real. That's for real. Okay. All right, let me finish reading this here. All right. It is worth noting that the court agrees generally with Judge Glanville's assessment of the property of the ex parte meeting. Wow, the meeting could have and perhaps should have taken place in open court. Now, that's the bottom line right there. That is the bottom line right there. The meeting could have been taken in open court. If they were not trying to hide something, why didn't they have it in open court? If they were not trying to hide something, why didn't they have it in open court? That's self-explanatory. It was something to hide. They wanted to put the pressure on Woody to make sure he testified because Woody said, I'm going to plead the fifth. And that was going to screw the case. But being as though that they did this right here, they screwed the case anyway. And they know it. They know it. So, all right, let me get back to this. While the meeting should have been taken in open court instead of in chambers, nothing about the fact of the meeting or the substance discussed was inherently improper. No, it was improper that it was a meeting without the defense knowing. However, in his order denying defendant Kendrick's motion and in the process of making his record on July 1st, 2024, Judge Glanville added facts, provided context, questions the varsity of allegations, and otherwise explained his decision and actions and argued why these actions were proper. So he's explaining, he says why these actions were proper. While it may be appropriate for the judge to disclose information relevant to his potential recusal, such as disclosures must be made in a way that is as objective, dispassionate, and non-argumentative as possible so that the judge is not reasonably perceived as a hostile witness or advocate. In presenting his record as to the recusal issue and in the ruling on Kendrick's motions, Judge Glanville, the Honorable Glanville, evaluated and accepted the truth of his own factual allegations mandated in the recusal. So he knew he was wrong. Bottom line, the judge knew he was wrong, man. The court has no doubt that Judge Glanville can and would continue presiding fairly over this matter if the recusal motion was denied. But the necessity and preserving the public's confidence in the judicial system weighs in favor of excusing Judge Glanville from further handling of the case. The motion was granted. Get him up out of here, man. Get him up out of here, man. They granted the motion, right? Motion granted. We're going to see where this goes, man. We're going to see where this goes, man. Because it's a lot of fuckery going on. It's a lot of fuckery going on. If you've been in that system, you've been to court, you know it's a lot of fuckery going on, man. If you don't got nobody to speak up for you, they gonna do what they want to you in that system. That's how it go. But let me know what y'all think about this, man. Let me know if y'all think Young Thug gonna come home. How y'all feel about the case. Do y'all think the judge was wrong? What about Little Woody? What about his attorney, Caleb Bumpus? She's the one that revealed that this meeting took place. So leave a comment. Let me know how you feel, man. It's your boy Deezy. Hit that subscribe button. Hit that like button. Share this video, man. It's not about the setback. It's about the get back. Now.